What's question, the next one?
Curt has often said that the current US Constitution has 6 great errors. Can you go over these and how an ally constitution will fill in the gaps?
Well, what I'd like to do is, because we held this one over, is list the 6 things. I don't know if I want to take up the rest of the story, the rest of the session with discussing all of them at length, because they actually, they're all around at one point. And so what I'd like to do is that, but if we could schedule a separate talk to talk about those 6 errors, I think that would be interesting. So is it okay if I just list the 6 errors and briefly cover them rather than going too deep? Is that all right with everyone?
Yep.
All right. I posted in the document the link to this page.
I'm sharing it just now.
So the founders were very educated men at a time when you could pretty much, if you're an educated man, grasp the totality of knowledge. I always think about it as back when I was programming, a programmer type, right? I was never just a programmer, but a programmer type. I could go through Microsoft's entire MSDN and TechNet publications for the quarter and read them all. I could go through all of the Oracle stuff. I could go through all the Borland stuff. I could read it all. You can't read it all today. I can't keep up with the ASI stuff that's coming out today. Right? So you can't keep up. You know, it's like, so they were in this period where they have a very syntopical understanding of the world, and there's a couple of things that have happened in their time frame. One is that they have their own crisis, which they understand is one of the trying to escape they have this incredible freedom now, and they want to maintain it. Or they have the freedom of settlers, and they want to maintain it. The second thing is they've got Blackstone's history of the common law, right? They've got Blackstone's understanding of that the common law is actually science. Right? They've got an understanding from both the church and the study of the common law that natural law and the common law are science, are expression of the science of cooperation. They've got Adam Smith, who tells them that this is the case. So they have David Hume, who tells them what the world looks like. This is all happening at this point. And so these people have created the modern vision, which is the post-medieval, early modern vision. Right? And so they didn't, you know, in their world, a lot of this stuff was just tradition, and it was understood. So they didn't write it down not with enough clarity to defend it. Well, why? Because they already had an unwritten constitution in England. Right? And so what they were saying is, okay, well, we got to write this down so it's our way. And they didn't even want to put the Bill of Rights out. They thought it was unnecessary. A good damn thing that they did. But is the Bill of Rights complete? It says it's not complete. It says this isn't a complete list. This is just what we want to have now. So they put those rights in as an afterthought, when what they needed to say was, this is the natural law. The natural law is this. The common law is this, right? The morality consists of these things, and this is the institutions necessary for us to practice this form of cooperation. Right? So essentially, they didn't put enough defense against smart people in the future coming up with new ways to try to invent manipulation, control, etc. So that's the first one, is that it's not complete. What do? We complete it, right? That's what we call strictly constructed, which is different, right? Different from how strictly constructed is used in the literature, right? So we mean as formally constructed. right? Which is it's a formal logic that unites the natural law, the common law, the concurrent legislation, and a government made out of markets. And we actually articulate all the first principles of the founding rights that are necessary, rights, obligations, and alienations that preserve them. So we write that out. So I am confident we solved that problem. All right. The second one is that there's a lag in time, right, between the innovations people come up with how to screw things up, and in other words, crime is a technology, immorality is a technology, rent seeking is technology, and there's a lag between the invention of this technology and the means of suppressing it. And so there used to be libel laws against both libel and slander, which is defamation, as well as fraud, but in addition against shrilling, which is what we call Karens, right? People who undermine the peace. So that the whole spectrum is there in the common law originally. But because the industrialization, all these revolutions happened really fast, men were full of agency first, and we suppressed male crime. But by the time we get to the introduction of women, we haven't codified the law for equally suppressing female crime. And we didn't even drag it forward into the Constitution. And so we have put back into place those laws against libel, slander, defamation, fraud, defamation, and undermining. We have put those three rules back in place. And the big thing with the slander and defamation is, right now, the way they get away with it is, well, in pursuit of free speech, we're hoping that the dialogue balances out. But it turns out it's so much cheaper to lie, and people want to believe negatives, that it turns out that that was a bad decision. So instead, what we've done is we've said, well, you don't need to prove that it caused real harm, like monetary harm to someone. You just have to be you have to be spreading information, GSSRM, gossiping, railing, shaming, that isn't testifiable, that isn't true. So if you say something about me, I have court available to me to protect my reputation. This also extends out from there to what we call canceling, which prohibits interference, because really what's the purpose of those three rules? It's to preserve a truthful discourse and the polity, and it's to what they call preserve the king's peace. Well, in other words, it's the lower form of sedition. What we've also included is we've included the higher forms of sedition, which is we're not allowing you to lie to the public and make false promises to the public. So we've handled both the negative criticism and the positive false promises. Part of that was number 3, which is we have free speech instead of free truthful as reciprocal speech. So this follows on for the previous change, which requires that we have free truthful reciprocal speech. So that what basically makes leftism go away. The next thing they did is they put freedom of religion instead of freedom of Christian religion. And the reason to do that, which is really, I had a hard time with this one, is that it turns out that religions are group evolutionary strategies, and they're incompatible with one another. And so you could say, well, I could be, you really have to be able to prohibit hostile religions from participation in any form of the government or any form of civic and public life. And so there's a difference between tolerating, right? So tolerating and allowing people to put up temples and churches and things like this and form social organizations, or in the case of Judaism and Islam, trying to introduce their version of law, of ethics into our law. Similar sections to number 5 is that you can pass legislation without it passing judicial review. And I'm like, well, how the hell did that happen? Right? The reason that happened is that the parliament used to be a court, instead of, in other words, it used to be a thing where you authorized expenditures, not where you started them, right? The monarchy would propose expenditures, and the parliament would accept or veto them. But once we took the nobility out of power, the parliament became the government, not basically the cabinet, which was a fuck up, by the way. So once we get to parliament, and what parliament turns into via positiva, and so there's no check, there's no real, other than the president's veto, which has various, very different quality. In other words, presidents have exercised this veto poorly in a lot of history, right? So there's no judicial review. There's no saying this is actually legal before it gets pronounced. So what happens is they make this shit up. They throw it into the marketplace. We try to thrash each other over it. It ends up in court 3 years later after all this damage has been done, or 10 years later after all this damage has been done. And then it ends up in the court, and the court resists trying to counter signal the legislature because, it's supposed to be the will of the people. It's not. Yeah, that's the other evidence. But then, so the court has to veto it. So there's no process by which the court can submit and force. There's no cycle where the court can submit and say, this is not law, you need to fix it, to the legislature, right? They just leave it hanging. So they leave the public hanging. And this is what's creating a lot of this uncertainty for us. So we restore that cycle of approval, disapproval, approval, disapproval. So there's a positive judicial review and a negative judicial review. Because a lot of legislation would never pass. And my last one, which I always get crap for, sorry, I'm right. I don't like to be right about some things. But this is something I'm right out, is that monarchies, when Washington refused to take on the monarchy, he screwed us over. And he thought he was being a good man, and he was a good man in most respects, but he was wrong. It turns out that of the different models we have, president and parliament, or prime minister in parliament, or monarchy, cabinet and parliament, the president is the worst choice, because you lose all the value of the intertemporal monarchy. In other words, the ownership versus renter, and you lose, and you highly politicize the role. So it's very difficult to have consistent policy. So in Germany, for example, because they have coalition-based government instead of first past the post government, they have coalition-based government. You can run a policy for 12 years. But in America, we can run a policy for 4 years until he gets kicked out. The next guy runs a contrary policy for 4 years until he gets kicked out. And this nonsense keeps happening. And it's worse in the House. So those are the 6 major mistakes that they made. The other 2 I don't want to go into now, but they're more to do with the more abstract problems that were unforeseeable, like the Darwinian revolution undermined the church and her role as insurer of last resort. And this ended up creating this problem of mixing the feminine church and the masculine, the pedagogy, which is positiva, and rule, which is negativa. And I think the point I wanted to make is that there's 5 constitutions already. The Articles, the first constitution, the post-Civil War, Southern Conquest Constitution, the Depression experiment with socialism, and 60s experiment with cosmopolitanism. So it's not like we haven't had huge constitutional reforms over time. It's just they've mostly been bad. And they're mostly been bad because of the 6 holes I mentioned. Now, is that going to help anybody listening to those holes? I have no fucking idea. Right? But if you look at the document as an algorithm for testing whether cooperation is functioning or not, then those are the holes in the Constitution.
You asked if it would help anyone, and I think one of the big things is for people to see that it's not that far off from what we need.
Right.
And I think that's actually the white pill in all of this, is that it's not that hard to fix. There's not that many things to fix, and that we're not that far off. It's just we've been not that far off for a long time, which has shifted.
Right.
It's more so that the original constitution wasn't very far off, but we're very far from the original constitution now.
So this is the problem, is that all other constitutions I know of are statements of philosophy, and the American Constitution is a statement of science. And it's somewhat like how the British really invent the Enlightenment, but the Enlightenment is really empirical. And that's all it was. It was just an empirical enlightenment. Was totally, but the French come along and they don't like the empirical enlightenment, so they bring about the French Revolution, and that is what spreads instead. Why? Because it isn't science. It's basically secular religion. So I don't know. I answer those questions. Noah brings up the correct response. Of course, Martin adds his sarcastic humors. I love.
There was no sarcasm. And no humor.
Well, I found it humorous and sarcastic. It was just true. Sometimes truth is sarcastic. So anyway, the real answer is that, people say we need a lot of constitutional change. We actually don't. We need a lot of constitutional clarification, and from it, we need a lot of policy change. It's not really that the Constitution is that far off. It's that there's no defense by the jurisprudence, by the legal system, against all this crap, this wokeness, etc. There's no defense against it. And partly we could forgive ourselves because we've just done, first we introduced the middle class, then we introduced the working class, and now we've introduced women, and now we've introduced aliens, basically non-Westerners, into this system. And we're asking the system who's insufficiently clear in juridical and legal terms to prevent the abuse of that system. It only started really falling apart, honestly. It fell apart really under Roosevelt, and it fell apart under the 1960s. But I mean, otherwise, if we hadn't had the immigration, if they hadn't fixed the 68 Immigration Act, if we just maintain a European country, we would have no issues today, really. That this would never have happened, because there would never have been a coalition large enough to undermine the country. Anyway, so I hope I've answered that question. If you want more specifics on it, we've written all this stuff, but again, people ask these questions because reading it all is tedious, but it is all up there.
Well, you have recorded an audio of this, I believe.
Sorry?
I believe that you've recorded an audio of this article.
Yes, I did.
Yeah,
I did.
it's right here, actually. And it's on the channel too, if they look it up. The Choice, episode 21.
Oh, yes, I'm sorry. Yeah, The Choice, episode 21, Correcting the Fails of the American Constitution and Our Germanic Origins, part 3. This goes on to show this Constitution, and then these errors of the Constitution, but the rest of the piece is to show how old these principles are. They're ancient, and I'm trying to make the point that Anglo civilization is just Germanic. It's West Germanic civilization. But what happened in the 1800s is that Britain became enraptured by what they'd learned from the Jews in banking. And England went divorced from Germanic culture. And it's interesting is that America is in the middle between the German and the English. It's actually sitting here in the middle, which is kind of interesting because we still have a lot of Germanic behavior here, even though we speak English. And that's because, of course, at the time of the Constitution was written, I mean, half the country was German. Okay, that's my point. Question number 2. How long did it take to answer that one? Yeah, another half hour.
We can maybe do 2 more.